Okay, we're going on the record on cause number DC 199922, Clark Ridge Canyon Limited versus THB Construction LLC. Council, make your appearances.
Good morning, Your Honor. This is Bob Arnett representing the plaintiffs, Clark Ridge Canyon Limited and Henry Building, Inc.
Your Honor, this is Scott Hayes representing THB Construction, the defendant in moving on the motion to compel.
Okay, let's go ahead and proceed.
Yes, Your Honor. Here on the motion to compel, we had previously discussed some of the facts in the motion for summary judgments filed by the plaintiffs previously, but there presently is an arbitration proceeding under the AAA construction industry rule involving these three parties. By agreement of counsel, that arbitration is stayed pending the court's determination on the summary judgment and motion.
Mr. Hayes, I want to make sure I recall the procedural history of this. There had been a summary judgment filed under the Declaratory Judgment Act saying that there wasn't a right to arbitration. I took that under advisement, and this is the motion to compel arbitration and kind of flows from that. Is that right?
Yes, Your Honor.
And and this had been the case where you guys were trying to use direct benefit estoppel or I think it's called alternative benefit estoppel to compel a non-signatory to arbitration. Is that right?
That is right. So the primary issue both in the summary judgment and today is whether Clark Ridge, which is the owner of the property, can be compelled to arbitration. It does.
I'm ready to rule on this, but if you want to make argument, you can.
Your Honor, I really don't have additional argument other than what's set out in the motion and responses we've argued before. If there's specific,
there will be one issue that I do kind of a side issue I want you to argue after I make my ruling. So I'll let you do that argument once I get to there. So, sure. Mr. Arnett, did you want to say anything else before I ruled?
Your Honor, the only thing I would like to bring to the court's attention is that there are provisions in both the subcontract between Mr. Hayes's client and the general contractor, and in the contract between the owner, Clark Ridge Canyon, and the general contractor, which state that neither of those documents shall be construed as creating a contractual relationship between the owner and the subcontractor. And since arbitration is a creature of contract, I think that further supports our position that Clark Ridge Canyon, the owner, cannot be compelled to arbitrate.
Okay, great. I appreciate that. I'm glad you brought that up. So I'm going to go ahead and deny the motion to arbitrate, motion to compel arbitration. I'm going to grant the summary judgment. And so really the only issue at this point is is it appropriate to seek attorney's fees on this for the motion for summary judgment on the declaratory judgment. So let's talk about that one issue. Mr. Barnett.
Well, Your Honor, the Declaratory Judgment Act does provide for discretionary fee shifting. I would point out that there are claims remaining in the case, particularly the owner's claims related to getting its title cleared of the lien that was filed, and potentially damages for filing a fraudulent lien under the Texas Property Code. So there are, the court's ruling on summary judgment, it's a partial summary judgment because it disposes of some but not all of the claims in the case. But I would, in terms of focusing on that discrete issue, I would think that and would seek fees under the discretionary standard of the Texas Declaratory Judgment Act.
Mr. Hayes.
Your Honor, I think it's an issue that's probably premature at this point in that, yes, we are going to have, there are various claims that will now be litigated, and I'm assuming counterclaims as well. We'll still have the arbitration will be proceeding, because there are claims that will be arbitrated between THB and Henry Building. So certainly in the declaratory judgment, the court has the discretion, but I think as the case proceeds, then it's more appropriate at that point.
Let me make sure I was accurate in my ruling. So you were only on this motion seeking to pursue arbitration as to the non-signatory subcontractor, correct? That wasn't, because I'm not intending to prohibit a arbitration between folks who actually had an arbitration contract, only between those who are only preventing those who were non-signatories to the contract. Is that understanding?
Yeah, that's the understanding, that the claims that Clark Ridge would have in this lawsuit will proceed. And second, in the arbitration, THB's claims now against Clark Ridge cannot go forward. But yes, I think we're of the same understanding on that issue.
Mr. Arnett, is that your understanding as well?
Yes, Your Honor. Effectively, there will be an arbitration, but it's limited to THB versus Henry Building, subcontractor versus general contractor.
Okay. You can ask Wanda. So, all right. Perfect. Anything else we need to discuss? Can you get me an order on both of these?
Yes, Your Honor. I thought I had, but if I will certainly do it again.
Well, I just want one order that covers all of this, including the attorney's fees issue. I'm not going to grant attorney's fees in this situation to either side. So under this discretionary standard here, I'm not going to allow attorney's fees. So I want that included in the order, and I want the summary judgment and motion to compel all combined into one order.
Very well. I will do that.
And so just go ahead and email that to my court coordinator as well as to Mr. Hayes.
All right, Your Honor. I think if it's all right with the court, I'll run it by Mr. Hayes before I submit.
Sure, of course. Yeah, that's what I meant.
We'll get a quick turnaround on it. So.
And then try to email that to her as well as e-filing it.
I will.
Okay. All right, guys. Anything else we need to chat about?
I don't think so, Your Honor.
Let me check one thing I need to about this case. Do you have a trial setting?
We do. It's in.
Yes.
So let me say one thing about this, just to be aware of, is I'm getting pretty strict on these non-juries. I'm not saying I wouldn't continue it because of the nature of the dispute and the arbitration issue, but because there's a good chance we're not going to have jury trials in September, since this is a non-jury, I would like to try it if we can. So if you guys can get it ready, I'd love to try it.
Understand, Your Honor.
Yes, Your Honor.
Okay. But I understand too if you can't, because it took me a while to rule on this arbitration issue. So don't I'm not going to be unreasonable. If you can get it tried, I'd love to get it tried.
Thank you, Judge.
Thank you.
All right. Thank you, guys. I appreciate it. You guys have a good day. Okay.
Yeah, you too.
And why don't the interns kind of wait around? Okay. All right, guys. So Gage, that was your memo, right?
That was, yes, sir.
So Gage kind of got to see the full circuit here. So,
Still on YouTube.
Oops.